I'm Christian Malesic, Executive Officer of the HBA of Berks County, Pennsylvania. And I'm not an attorney. I am an MBA. We're going to translate the lofty ivory tower language of the attorney into thingamajig, how you doing, and whatchamacallit, so that the average Joe and Jane contractor can apply it to their business today. Although this is based on Pennsylvania law, it will apply in most other states as well. Every time when we're thinking about legal issues and contracts, the question you have to ask yourself, and I know some of us want to stay clear, I'm not the sue type, I don't like to get lawyers involved, can't we just do it on a handshake? Can't we look eyeball to eyeball, belly to belly, grip and grin, let's do it like men, let's do it like ladies, let's do this the old-fashioned way. Well, you might think that, but the rest of the world doesn't. And so if that's the way you are, I believe that, I strongly adhere to that myself. And then, oh, by the way, let's just put what we all agreed on paper over here so to make the lawyers happy. We have to. Not because I don't trust you, but because I don't trust whoever else. The building that we sit in right now is part of a complex of 16 units. And this particular complex of 16 units, 2.3 acres, has had at least four that we know of, 4 landlords in the last 6 years. So we literally have inherited the contracts of every one of our tenants. Literally has a different lease that was either made by different terms. I mean, everything we're going to talk about today, they're just all over the place. I had to make a very crazy flow chart to help me, or really an Excel spreadsheet, so that I could understand this person has this, and this one has that, and that, and there's no 2 tenants that are exactly the same. Now, obviously, we're rectifying that. In fact, one of the documents that I'm going to pass around today is our commercial lease for our tenants here. First of all, when you provide your contract, you're going to do a standard form contract. Here is the Home Builders Association standard form contract for leasing the premises that we have 16 suites, as I said earlier. So here is a 18-page contract that's been thoroughly vetted. I think it's probably the best commercial lease agreement I've ever seen. As a member, if you would like one, you certainly can have it electronically and make it yours. Obviously run it by your own attorney, but it's been run by numerous attorneys. We've combined numerous leases that were, the greatest work from a lot of great minds into one. 18 pages long. Okay, well, that's what you're going to do in your business. You're going to take the time and work with the lawyers and back and forth and this and that, and you're going to come up with the perfect contract that meets your needs. You're going to save it electronically in your iPod or your smartphone or on your laptop or on your desktop. And then anytime you need it, you're going to fill in some information. And you're going to get it out to the homeowner or the vendor or the subcontractor, the trade contractor, whatever the case may be. What we recommend is make it so that all you have to do is fill out the first page and the last page. And everything else in the middle stays the same. Don't put the scope of work. What so many of us do as trade contractors is we try to cut and paste the scope of work here on page 3. Don't do that. You've already written up a quotation that you provided them, and or whatever you called it, a bid, a proposal, or whatever. Just have it with an empty line. This references quotation number 1234 dated June 15th of such and such a year. And that way you have all of the information that you need to tweak and change on page 1 and the last page with the signature information. If you have to go to additional pages, it should be page 2. In our case, we have a pretty comprehensive lease. We need it to go to a second page. So when I am filling out one of these leases, I only need to go to page 1, 2, and the last page, fill out the details there, and then hit print. I don't even need to look at all the stuff in the middle. We've looked at that ad nauseum 100 times. If I need to attach other supporting documentation, I put it in here as check blocks. If I'm going to have now this doesn't have this because this is not a contract for work, it's a contract for leased premises. But for you, there's going to be times when you may have a progress payment. You're going to have a certain payment that's due at this point and a certain payment that's due at this point. And so what we would always do is we would have check blocks, and it would say progress payment schedule. A progress payment does not apply to this agreement, with a little block, a little square. And the next one below it, a progress payment does apply to this and is attached at attachment. And we check off that, the appropriate block, and we put attachment A, B, C, D, E. And we attach it to the back of the document, and there we have our contract. We attach that with the contract, and there we have our document. So it becomes very easy for you logistically to knock these things out because you're providing all of these proposals, you're taking calls. Some of those people want to schedule appointments, some are just asking questions. You go out on the appointments, some of them are home and some of them blew you off and they were no-shows at their own home. And then you're doing a quotation and some of them are saying, I want to do the work, and some of them aren't answering the phone or the email after. And then you're sending a contract and some of them are filling it out and some of them aren't. So by the time we get down to this step, you've been working with this customer, with this potential buyer over and over and over. We want to speed up the process, but we still want to protect our legal rights. So that's how we can do that. Do we have to initial every page? No, but it does certainly eliminate any question marks later. So this is something that the realtors do. Now they have to do it by law. So when we're trying to buy property or sell property, it has to be done. It's easy enough to do. You put buyer's initial, seller's initial. In this case, it says HBA initials, tenant initials. It could certainly say, owner initials, ABC contractor initials, whatever the case may want to be. You don't have to do that, but by doing that, then they can't go in a court at a later date. Oh, I never saw page 4. I didn't know it said that. Your lawyer goes, are these your initials, Mr. and Mrs. Jones? Yeah, well, I didn't read it. You got them. Right? In that case, the law's on your favor. They initialed it. You got them. Especially if you do something like at the top. Big bold letters at the top. This is a legal document. In big capital letters, bold, 13-point font. Do not sign this lease agreement until you have read it carefully. If you have legal questions, you are advised to consult an attorney. Now, why do you need to say that? Isn't that like saying the coffee at McDonald's is hot and you put it on the side of the cup? Why do you have to say that? Because some lawyer somewhere didn't say it, and some other lawyer somewhere said, well, it didn't say they should consult an attorney, so how did they know? They're a dumb American. What do they know? Well, you signed it. Didn't you read what that says? It's in bold, all capital letters. 14-point font at the top. Some of it's silly. We're talking about the legal system. So you gotta take common sense and set that over there. That doesn't apply. Let's talk about the legal system. If you want to talk about common sense, that's a different conversation. So we got to do the things so that they protect us. That's what this is all about. We already kind of talked about including plans, specifications, samples, color choices, quotations. All of that kind of stuff can be an attachment. Attachment 1, 2, 3, 4, attachment A, B, C, D, whatever you want to do in your contract. Actually set it up so that you have a standard contract. You're never changing your contract. You're just filling in the drop-in boxes, and you say a color choice page is applied or is attached at attachment. A progress payment is attached. Specifications are attached. Plans are attached. You want to definitely have them initial and or sign and date every single one of those pages. Certainly if you're doing plans, mock-ups, that should be signed and dated. So that we all know, well, you picked the color choice, you saw the swatch. If it's something that can be signed, sometimes you can actually sign a piece of countertop or something like that, and you just put that in a box somewhere. If you can do that, do it, if you can get enough of them. If you can't, then at least, a piece of paper that says, I choose the color gray granite, or whatever the name may be, Mexican tan, or anything below the signature line doesn't apply. So if you put a note below the signature line, oh yeah, what we wanted to do, for example, the apartment that I currently live in as I'm buying my house, my landlord wrote on the bottom, no smoking in apartment. Now I'm not a smoker, but legally I can smoke all I want because he put it below the signature lines. Doesn't apply. It's like an afterthought. It's kind of like putting it on a sticky. Doesn't mean anything. So anything below the signature line doesn't apply. So if you're sitting down to do a contract signing and they go, well, how about this? Either write it above the signature line or get another piece of paper and say, you might, if you think that that's going to happen a lot, right above the signature line, put a couple of blank lines, in which case you could say the additional note is attached, or if it's not used, you actually line it out and you put not used so that people can't write in later and say, well, it says right here. Well, my initials aren't there. Well, this is the copy I have, and they're scamming you on the back end because we have those kind of people out there. We do want to have both parties of the contract sign if we're talking about a husband and wife. If we're talking about a partnership, we want to have more than one partner unless we have a managing partner, a general partner. If it's a corporation, it is okay to have the CEO or the president or an officer of the company sign. You don't need to have numerous numerous people sign. You also do want to have a personal guarantee if you can. I'm going to send this around for you to look at. And if you can get them to agree to a personal guarantee, especially if they're, if they're a big company like Home Depot, the manager's not going to give a personal guarantee. But if they're like most of the people we deal with, they're 50 employees or less, they may, and that's just an arbitrary number, they may be willing to sign a personal guarantee. And so you just have your lawyer put language in the paragraph above in the contract, and you have them do a separate signature that they personally guarantee. Now, if they bring their LLC or corporation or sole proprietorship and they decide to take that bankrupt so that they can take the millions of dollars that they made on the project and decided not to pay you, you can go after them personally, and you can take that house, that boat, that motorcycle. My favorite one is that dog, that cat. People forget that horses, dogs, cats, rabbits, hamsters, they're not considered people, they're considered property. So you really want to get a person's attention? You sue for their dog.
That's pretty cool.
Yeah, well, I mean, this is the person not paying you the $30,000, $50,000 that you did their project, you delivered their material, you did everything you were supposed to do. Who's being cold here, them or you? You see what I'm saying?
Right.
I mean, you're playing defense. If you're going to play defense, if you're going to drop the gloves, if they drop the gloves on you first, is really what happened. Then you're going to drop the gloves and fight back, or you're going to, fight or flight, or you're going to eat it. You're going to say, "Oh well, cost of doing business." If you decide to fight, then fight to win. That's what my daddy taught me, at least. The next item: avoid trade custom terms. We have a lot of terms that are both local to Berks County. It's kind of some of the Pennsylvania Dutchism that has crept in over the years. But we also have tradecraft terms that are things that we say. For example, after the mud is applied. Well, even in our world, mud means a whole lot of different things. Mud is the drywall compound, the joint compound that's applied to drywall to smoothen the joints. Mud is also the term that the concrete guys use when they're spackling. They call that mud. Obviously, the excavators talk about what everybody calls mud, dirt mixed with water. So we wouldn't want to use something like that. Obviously, we wouldn't want to refer to the electricians as the Sparkies or, whatever the case may be. We want to be professional, not because we can't use slang, but because the definition a county over or even the judge who happens to be hearing our case may not understand what that means or might interpret it different. And let's face it, the lawyer for the counterparty is going to always try and find something that fits their client. So if they can find a definition in any book anywhere throughout the history of time that term or trade term means something different than you meant, guess what? They're going to use it. What's interesting is that ambiguities are resolved by the courts against the drafter. So this is kind of like that old game, or if you have kids or you have kids now, you may play it. It's not so much a game as a way that you determine fairness. So we have a candy bar, and I have two preteen daughters, and we only have one candy bar. And I told them that they could split it. Well, how do we determine who gets how much candy bar? Well, the way we do it is we say, one of you break the candy bar in half, and the other one gets to pick which half they want. Now, am I going to break it, if I'm one of the candy bar people, or the daughters in this case, they're going to break it as perfectly even as they can, right? Because if they do 60-40, they might only get the 40. Well, that's the way the law sees contracts. So ambiguity, right, a word that means if we're not sure. If I can read it one way, and you can read it another, and he can read it another, and she can read it another, it's not clear, right? The drafter did not make their intentions clear. How does the judge look at that? The judge always resolves it against the person who did not draft it. So the other party, one of you is always going to draft up the contract, right? You're going to type it up. And then the other's going to look at it, maybe tweak this and tweak that, and then you're both going to sign. So whoever was not the drafter, that's the person that wins those battles. Now, that being said, I think pretty much every attorney would recommend you always write the contract if you possibly can.